All right, welcome everybody. We're going to go ahead and get started. We have a webinar. It's going to take us about 20 to maybe 30 minutes, depending upon the questions regarding COBRA administration. It's something that a lot of employers are looking at seeing, or at least reviewing at least once a year. And our topic today is just the top 10 mistakes and how to avoid them, because one of the challenges that we continue to hear about is the new auditing that's going to occur regarding the IRS and having to do with ACA penalties and some of the other follow through there. And we just want to help out on one of the rules that's been out for quite a bit of time, but there's still a lot of concern about making sure that it's being done right. My name is Tyson Fuhrer. I'm the Compliance Division Manager here at Biggs Insurance Services. If you would like and want to contact me, have some questions, maybe something that comes to mind afterwards, feel free to email me or call me direct. That number and my email address is listed. I'm going to go and get started here and just talk a little bit more about an introduction to COBRA. COBRA was started in the late 80s. It came as a bill signed by President Reagan. It was built to be a continuation of coverage, really basically trying to help people bridge the gap between two coverages. In fact, the main reason that it was generated was back at that time, there wasn't any continuation coverage available to, say, spouses or children in the case of a divorce. And so this type of coverage provided an opportunity then for people to not be taken completely off of health coverage, have the ability to have health coverage, because in the individual market was very difficult to be eligible and on at that time, much different than it is now where pre-existing conditions have gone away. People that go on to COBRA are known as beneficiaries, and they are eligible to be on COBRA because of qualifying events. Non-compliance, though. So one of the things that happened when the original bill was signed, there was a new bill called TAMRA that was signed a couple of years later that started to put in some enforcement rules and who was going to enforce those rules. And the IRS has always seemed to be that one person where they can implement $110 per violation per day penalties. And then what gets really expensive is when not necessarily just $110 or even just the lawsuits, but when the employer then has to become the insurance company. A lot of times when COBRA violations occur, the health insurance company will drop coverage, return premium, and tell the employer, now you get to cover these people 100% out of your pocket, which generally means that it's going to be a lot more expensive than just that little bit of premium. Okay, we're going to go kind of starting with number 10 on the issues that people run into with regards to COBRA. Number one thing is just making sure that they understand if they're eligible or not. COBRA eligibility is based off of a calendar year. It really doesn't matter when your plan renews. It's all based off of a calendar year. And you'll know you're COBRA eligible that if in 50% of the business days in the previous calendar year, you had 20 or more full-time employees or equivalents of full-time employees. This becomes a little bit of a challenge in that most employers may or may not be tracking that. It's probably becoming easier now with the ACA rules that are out there and relying on payroll companies to help with those resources. But probably the trickiest part is that you would have a full-time count of employees. Those are people that are 30 hours or more, or based off your benefits package, eligible at full-time. And then you would count the hours of part-time employees as fractions of a full-time. So let's say 30 hours is the minimum requirement, but you have two part-timers each working 15. That again is 30 total. So that would be the equivalent of one full-time worker. So if you had 19 currently enrolled, and then you had these two part-timers, that would make you 20. Assuming that you had that same workforce in 50% of the prior calendar year, that means that your company would be COBRA eligible and need to follow the rules that the federal guidelines employ. Now, there is a small employer exemption in the state of Oregon, for example. There's state continuation, which is also called mini COBRA. It doesn't treat and have the exact same timelines, but it also exists as well. However, companies that are under 20 are not required to follow the COBRA continuation rules. Number 9, assuming COBRA doesn't apply to your plan. COBRA applies to all group plans that are maintained by the employer. There's a lot of questions about COBRA, and I've seen some interesting case history on employers getting sued over little things like a EAP plan not being offered through COBRA. So just in general, the easy ones to remember is medical, dental, vision, prescription drugs. Those types of plans are pretty commonly accepted as far as being COBRA. The ones that sometimes get missed are some of these extra add-ons. So EAPs, again, for example, drug and alcohol treatment plans, wellness programs, different types of reimbursement programs. FSAs are probably the most tricky of all of them, in that if an employer has contributed or an employee has contributed more than they've been reimbursed, the FSA then needs to be extended as a continuation benefit. But if it's the opposite, where the employee has been reimbursed more than they've contributed, then FSA does not apply. HRAs may be a little tricky in that you have to come up with COBRA premiums, because a lot of times these are just self and reimbursed type programs that may not have a premium or a well-known fully insured equivalent premium. So those are some plans that are subject to COBRA. Plans that are not subject to COBRA, you have long-term care, your AD&D and life type plans, LTD and STs, your disability programs, wellness programs or employee assistance programs that do not provide medical care. That is probably one of the most difficult ones to decide the difference between, but those plans would be or would not be COBRA eligible. Exercise or fitness centers, so you have a lot of companies now, the larger ones, that are starting to put in their own on-site facilities for a lot of different things. And so sometimes those would be COBRA. A lot of times they're not COBRA eligible, but there might be a case that they could be. Now, one of the things to remember is that canceling your plan doesn't always cancel COBRA responsibility. And what I mean by that is if the employer continues to provide any group health plan, they still have to provide COBRA continuation coverage. So that may be a little tricky, but something to ask questions or get some answers on specifically. And maybe you have a third party that does that for you. The number 8 item is not knowing your qualifying events or qualified beneficiaries. So remember, qualified beneficiaries are the folks that are able to continue coverage because a qualifying event occurred. Qualifying events that are actually triggering these types of things are identified by individuals that are currently covered by the group health plan on the day before the qualifying event. So that could be involuntary termination or a voluntary termination. You have, and this is probably the part that gets lost a little bit, is that you have the employee's spouses and dependents that were on the health plan when the event occurred. You can't just add somebody mid-year because then it's not a continuation benefit. However, at open enrollment, they could then re-elect just like a regular employee to add dependents or take them off at that time. Okay, so that's something that you have to remember when you're sending out those qualifying event letters to make sure you get it to the right beneficiaries. Sometimes retirees, those plans are really starting to go away with healthcare reform, but you have to deal with spouses and dependent children, or now you have these adult dependent children, which are the folks that are maybe college age or up to age 26. You do have to deal with adoption, and sometimes you'll include independent contractors and directors inside the health plan if, again, they're continuing coverage. What are qualifying events? These are the things that, again, trigger the qualified beneficiaries to continue coverages, but it requires a cause or will to cause a loss of coverage, and there are maximum coverage periods depending upon the type of qualifying event it might be. The minimum is 18 months, and then it can go up to 36 months. Okay, FMLA is probably something that becomes a little more difficult to manage when you have a qualifying event, because you're dealing with somebody that is going from FMLA to COBRA, or maybe even you're dealing with workers' comp as well. So these are some of the timelines that you want to be very careful with, because if you're offering coverage or continuation coverage to COBRA too soon or too late, the qualifier may not be accepted by the insurance company, which then means the company gets to take on the claims. Okay, so just pay attention to the terms for eligibility. A little more information about qualifying events. Qualifying events for employees are termination of employees for reasons other than gross misconduct or reduction in hours of employment, which may be voluntary or involuntary. The gross misconduct is probably the thing that comes up the most if you deal with the Department of Labor or the Employee Benefit Security Administration. They're going to tell you that defending gross misconduct is very difficult, so a lot of times they just recommend go ahead and offering the COBRA coverage. Qualifying events for spouses, again, are termination of covered employees' employment other than gross conduct, reduction in hours, covered employee becoming entitled to Medicare, so that's the individual employee working for the company becomes entitled to Medicare. Now that can be a qualifying continuation event for the spouse, divorce or legal separation, and death of the covered employee. When deal with dependent children, loss of dependent child status under the health plan rules, so that would be your age. Remember, age of up to 26 is pretty much every health plan has that nowadays. Termination of covered employees' employment, reduction in hours, covered employee becoming entitled to Medicare, divorce or legal separation, death of a covered employee. So a lot of those match and mimic the spouse. Okay. The number 7 reason, giving no information. That's probably not the best way to phrase that, but plan administrators are required to provide certain information to plan participants and beneficiaries and qualified beneficiaries. Those are done through COBRA notices, and there's specific rules about the timing of those notices, and it's really important to make sure you know what those are, because they all have different periods of time and can become very confusing when it comes to when someone has to elect versus when someone has to pay initially versus open enrollment and continuing premium payments throughout that period of time. But it's always important to make sure that you're documenting all of that information, because if you ever are audited by the IRS, you're going to need to be able to prove which letters went out and which timelines are actually properly being administered. The general notice is probably one of the ones that is forgotten the most. In fact, the Department of Labor has come out to say it's the number 2 most important notice because it's the number 2 notice that always gets forgotten. This is the notice that goes out to employees that are actively working for the company and are enrolled on a health plan. You have 90 days to send out this general notice. And the reason why it is so important is that it does provide the obligations to the individual of if there is a qualifying event, what they're required to do. Okay. A lot of times these are sent and mailed to the individual employee, and might note that the beneficiaries or insured health plan members are also included on that letter, so you don't have to send more than one letter. Otherwise, you got to send them to each individual. Qualifying event letters or election notices. This allows the employees then to continue coverage. If an employer is not using a third-party administrator, they have 14 days to notify the qualified beneficiary of the qualifying event through the election notice. If the employer is using a TPA or plan administrator, they must then notify that TPA within 30 days, and then the TPA has 14 days to get it out. Okay, hopefully that makes sense. There are some other notices out there. The notice of unavailability. These are when a plan administrator is notifying an individual with an explanation of why he or she is not entitled to COBRA coverage, which may mean that there's no qualifying event. Gross misconduct might be in there, but these are really important and notices to get out, because otherwise you could get challenged in court. There are deadlines as well with these, and again, you've got the 14-day requirement. Notice of early termination. A plan administrator must notify qualifying beneficiaries when continuation coverage terminates before the end of a maximum coverage period of time. There is different timing again with this, and you also have to tell them why they're being terminated early from COBRA. So there's different reasons in there. The date of the coverage needs to be involved, and then if there are conversion rights, you need to notify those. There are new notices that are going out that a lot of times include the ACA or exchange information about how they can enroll in individual exchange that are required inside of these notices as well. Okay, this talks a little bit more about a qualifying event, and we already talked about those earlier, so I'm going to go ahead and pass over the top of these. The number 6 reason and things you want to avoid is giving bad information. Inside your general notice, which again is the one that goes out to active employees, you need to list the items that are put into these different bullet points here. So you have things like plan name and addresses and all those types of things. The reason why this is so important is that if you don't send it out, then the employer then becomes obligated to be able to make sure that they can get the qualifying event letter to the individual. One of the things that the initial notice or general notice provides is to tell the active employee that they need to let the administrator know if they have a change of address. Some things that have come up in case law has to do with the general notice not going out, and then the employer just sending it to the last known address that they had, even though the individual had moved, and then the individual said that they never received the letter, and because the general notice didn't go out, the employer was obligated to get that letter to them. They did not in the timeline as required, and therefore they received a violation. Okay, there are model notices available, and we're going to provide a link at the end of this that you could go ahead and click on and download those as well. It's always recommended to get the newest notices because there are changes to the letters, and you are required to prove that you're sending out the most up-to-date letter in the appropriate period of time. Your election notice has a lot of information as well. Most of it is similar to the general notice or initial notice. There's additional information as regarding continuation of coverage and electing or waiving onto that, and the timelines that they're required to return those notices back. This is more information. And again, model notices are available on the Department of Labor's website. Number 5 reason, not following procedures. This is why people will file complaints. Just that you know, as a point of reference, is that the IRS generally does not ever get involved unless there's a complaint that's filed. And generally you get complaints from unhappy employees because you let them go. Kind of the trigger is they call the Department of Labor because there's a lot more information for them to do that. They're much more knowledgeable than they probably ever have been. Department of Labor will tell them, hey, you may have a case or you may not. But go ahead and feel free to reach out to your attorney, and then that's when the attorneys start working down the list. When the attorneys get involved, what they will do is that they will call the plan administrator and require that you deliver all the timelines that everything was sent and different information like examples of the notices that were sent as well. They're looking for things that they could come back after the employer on. So it's always important to put reasonable procedures in place, have those documented and included in different places. For example, maybe an employee handbook is going to let them know that the initial notice and how that's delivered. But following those procedures and documenting them is extremely important. If you don't have the reasonable procedures in place, these again are ways that you can get in trouble, and these are ways that complaints may be filed against the employer. Here's some places that how you describe the different procedures. How you handle notices of qualifying events. Disability, this is another one that will come up if someone becomes eligible for SSA. You have different letters that are involved there, and then you may actually have an extension of COBRA as well beyond the 18 months. You have your election procedures, payment procedures. Employers are allowed to charge an additional 2% above the actual premium for administrative expenses unless there is a disabled qualified beneficiary, when then you're able to actually charge 150%. Do not have to, but can if you'd like to. One of the things that's really important is to know when premium payments are required. So when you deal with the initial premium, it's 45 days after the election. You may have seen in the prior slides there that the employee has 60 days to make an election. And then after that, because they don't have to send in initial premium, they have another 45 days on top of that to actually make a payment. Okay, so that's really 105 days. Once they send that in, now all of a sudden, now they're COBRA. And just know that that's retroactive to when they lost coverage. It's not to when they made payment for coverage. And then they have to pay the premium on the first of the month, but they also have a 30-day grace period. Something that's important to know here is that the employer must track usually the postmark date on the envelope from the premium payment, because that's actually when the letter is deemed to be received, not when it actually shows up at the office of the employer. So make sure you have some bandwidth in there from when payments may have been mailed versus not received. Another reason to avoid when you're dealing with COBRA is number 4, not giving enough coverage. So continuation coverage is provided to qualified beneficiaries. It's the same coverage that the employer's offering to regular employees as well. Okay, so it's not really a differentiating coverage. It's all the same stuff. That's why they call it continuation coverage. They are entitled to the same benefits, rights, and privileges that a regular employee also receives. Understand at open enrollment, when you make changes to those plans, it's also going to change the qualified beneficiary in the plans that they are needing to reelect. And they're also going to have the same timelines to be able to make an election based off of when they receive the open enrollment materials. But you do need to notify them when any changes happen, just like you would the regular employees. Number 3 reason is charging too much or too little for COBRA. Okay, sometimes, and we mentioned this a little earlier, was talking about HRAs, or health reimbursement arrangements. Those have to have a fully insured equivalent premium, even though they're just reimbursement programs. You're required to provide those types of premiums. So you would be charging, and they would make an election for that. Okay, so you may be charging too much or too little. You have to be able to defend the premium that you're charging. If you charge above the 102% or the 150% that we mentioned in the last slide, those are items that you could get in trouble for. When you're dealing with states that are age-banded rates, this is another challenge that you come up with. Sometimes employers represent to the employees, the regular employees, that there is a consolidation or an averaging of the employee-only rate, even though the insurance company is actually charging different rates based off of age. When COBRA comes around, you have to charge what you charge the employees, which means that consolidated rate is what you get a charge. And so you may have an older individual going on to COBRA, and they may be having a premium that's higher than what you were charging the regular employees. The employer then has to eat that cost. It's not something you can get around. So defined contribution plans can sometimes make that a little bit easier to manage, but it's something to definitely consult with your broker. If this doesn't make sense, please feel free to send me an email. I can describe it a little bit more in depth, but not everybody on the line today actually deals with age banding, so I don't want to spend too much time on it. Another thing I really want to mention too is that COBRA premiums can only change once per 12 months. So they're fixed inside of a period of time. So you can't go in and have different changes. Like you may have a refiling of the rates. You can't actually charge more for that premium. You can't charge more than it actually costs, but you can't charge more to pick up the difference. The employer then has to deal with that. Okay, so these are some things to be careful with, because this again could create complaints on the employer's behalf. No documentation. This is when a complaint comes into place, the employer is going to need to provide different things like when were things mailed, what letters were sent out, making sure all the timelines were followed, because that's what the attorneys are going to be asking for and where the violations would occur. One of the things that's recommended, particularly in your qualifying event type action, is certificate of mailing. And what that is, it's not certified, it's not registered mail. It does not require a signature from the individual receiving the mail. You go to the post office, they stamp it, it's good as mailed at that point. The employer has met their obligation. If you send a certificate of mailing, certified mail or registered mail where there's a signature required on the recipient, and that mail is returned, the employer then again still has to continue to send that out. If you send it out first class without a certificate of mailing attached to it, you have no proof that that letter went out. This is a documented item with the post office that makes it simple and easy to make sure that you can document the information that was sent out and at what timeline. Bad timing. So here's another one that will catch up with an employer. There's maximum coverage period. So if an employer offers a COBRA beneficiary coverage beyond their 18 months or their 36 months, they become the insurance company. Okay, if they don't offer it enough time, they again the insurance company can deny coverage, and then the employer becomes again the insurer. So these are really important. There are some different special rules regarding newborns and adopted children and their maximum coverage, but it's really important that you follow these timelines. Here's some information about expanding COBRA coverage. And these are again about the bad timing. So let's say you have a multiple qualifying event rule, which extends someone from regular 18-month coverage to 36 months. These happen for spouses and children that are enrolled on the plan through COBRA's continuation coverage. We create these secondary qualifying events that just extends their coverage out. Deal with disabilities, and you deal with a couple other items as well. And here's some of those other items. Terminating COBRA coverage. COBRA coverage generally terminates at the end of the maximum coverage period, but there's not a notice to the qualified beneficiary required, only if there's early termination would you need to do that. You're able to terminate COBRA coverage if a qualified beneficiary does not make timely payments. So remember, they're required to pay on the first of the month with a 30-day grace period. And you have a couple other reasons, but that's probably your biggest reason right there. Should you have any questions, one of the recommendations we always have is get a hold of the Department of Labor, and specifically the Employee Benefit Security Administration. They are regional, and here is the Washington and the Oregon telephone number. They will respond very quickly. You do not have to stay on hold for very long. There's also a great website, the departmentlabor.gov at the EBSA. Provides a whole lot of information. They provide model notices, posters for employers. They also have a great employer COBRA guide. Obviously, feel free to reach out to me or your broker, and they can provide a whole lot of information regarding COBRA. Just make sure that you don't get stuck in the information that you may not know and you're guessing. You always want to get a reference item to make sure that you're following the proper timelines. Should you not provide the proper timelines, always try to follow through with best intent, and sometimes that will make sure that you're not going to get in trouble with the IRS or Department of Labor. I appreciate everyone's time today. We went through that pretty quickly, but again, go ahead and feel free to call or email me should you have any questions in the meantime. Have a great day.